Go ahead, Jeff.
Good afternoon, everyone. I'm Jeff Swanson. I'm a professor in the Department of Behavioral Science and Psychiatry here at Duke University School of Medicine and a faculty affiliate at the Wilson Center for Science and Justice at Duke Law School. And on behalf of the Wilson Center and our co-sponsors at the Johns Hopkins Center for Gun Violence Solutions, I'd like to welcome all of you to today's webinar, Extreme Risk Protection Orders in Practice, Balancing Risk and Rights, Ensuring Justice. I'd like to remind everybody the webinar is being recorded and will be posted on the Wilson Center's website at Duke Law as a resource for ongoing public education. So let me start with why I think this conversation matters today. Extreme Risk Protection Orders, ERPOs, sometimes called red flag laws, now cover more than half of the U.S. population. So more than half of the population lives in a state that has an ERPO law. And ERPOs give law enforcement clear legal authority with a civil court order and due process to temporarily restrict firearm access when a person is behaving dangerously and at substantial risk of harming themselves or others. But in evolving practice around the country, ERPOs are not operating in the same way everywhere and surely not in isolation from other institutional systems. They sit at the intersection of public health, public safety and behavioral health crisis response, civil law, and in some cases, the criminal legal system. That intersection is where the Wilson Center for Science and Justice does its work. The Wilson Center's mission is to advance criminal justice and equity through nonpartisan, evidence-based research, policy reform, and education. And our behavioral health core, as part of the center, focuses on improving outcomes for people with mental health and substance use challenges who are involved with the criminal legal system or adjacent to it, reducing unnecessary incarceration, strengthening crisis response, and supporting diversion and deflection. ERPOs can touch all of these domains. They can function as a preventive public health intervention, as an alternative to criminal charges sometimes, or as parallel civil tools used alongside law enforcement. They raise important questions about procedural fairness, about racial equity, and how to support individuals in crisis without deepening their entanglement with the criminal legal system. So I'm hoping that today's webinar will provide, at least in brief summary, an overview, a clear overview of the history and legal design of ERPOs, the evidence for their effectiveness, models of implementation across jurisdictions, and future challenges, whether they be legal, practical, ethical, or let's face it, political challenges, and that states face as ERPOs continue to evolve. So let me introduce our panelists. We're fortunate to have with us today three of the most experienced, distinguished ERPO policy leaders and practitioners in the country. My friend Josh Horowitz is a lawyer. He's the Dana Feitler Professor of the Practice at the Johns Hopkins Bloomberg School of Public Health. He co-directs the Johns Hopkins Center for Gun Violence Solutions, and he's the principal investigator of the National ERPO Resource Center. Josh has spent more than 3 decades of his distinguished career translating public health evidence into firearm injury prevention policy. He essentially founded, with its first convening in 2013, the Consortium for Risk-Based Firearm Policy, the group that developed the legal template for the modern ERPO law and promulgated a recommendation that resulted in now nearly half the states adopting ERPO laws. So welcome, Josh. And next we have Lisa Geller, who is Director of Implementation for the Johns Hopkins Center for Gun Violence Solutions and co-lead of the National ERPO Resource Center. And I think of Lisa as the ERPO implementation czarina. So we're glad to have Lisa. She has trained thousands of ERPO implementers across the country, and she's a national leader in applying implementation science. Has written an article about that to ERPOs and helping jurisdictions build systems that are effective, equitable, and sustainable. And finally, we have Kimberly Wyatt, who's a senior deputy prosecuting attorney in King County, Washington, and a founding member of the Regional Domestic Violence Firearms Enforcement Unit, the first dedicated ERPO unit in the United States. Kim is a pioneering ERPO practitioner whose work illustrates how ERPOs function in real-world high-risk situations, often at the intersection of behavioral health, crisis response, and the criminal legal system. So, Josh, let's start with you. You have been at the center of this story from the beginning. You were a key driving force behind what now seems like quite a historic convening in 2013 after the Sandy Hook shooting and what became the Consortium for Risk-Based Firearms Policy, which was an effort that paired science and advocacy to create the first modern ERPO model, um, grounded in evidence that dangerous behaviors, not a mental health diagnosis, should guide firearm policy. So, and since then, you've shepherded ERPOs from an idea to a national policy tool, and now in more than 20 states, and you lead the Johns Hopkins ERPO Resource Center, as we've said, which has trained all these implementers. So let's start with the big picture. How do ERPOs fit into the larger history of U.S. gun violence prevention policy? By legal design, what's the ERPO piece in the jigsaw puzzle? And how are they different from categorical gun restrictions at the point of sale, just conceptually? And looking back at the first decade of experience, what do you see as the most important lessons about how these laws emerged and how they're being used and where we go next? You can answer any of those questions if you want.
Well, thanks, Jeff. I'll jump into a bunch of them. I think at the start, I mean, ERPO fills a very important need that we didn't really have in the past, right? It was either before we had these extreme risk protection orders, it was either we're going to trying to prevent someone from having a gun to start with, or we're going to criminalize them to remove a firearm, or we're going to commit them to remove a firearm. And what ERPO does is create a different type of intervention, one that I think is an opportunity to remove a firearm from someone who's really dangerous, but also at the same time trying to get them the help they need, trying to make sure that they can thrive. This is not an opportunity to really be punitive against somebody. It's a new way to think. It's about preventing a harm and making sure that the individual who's the respondent in this, right, his life is better at the end, right? Not necessarily worse. And so I think it's an interesting approach that didn't exist in the past. So it's definitely a way to reduce and mitigate danger, but it's also a way to make sure it's a different type of step than criminalizing somebody or committing them against their will and making and being like hospitalized for a while, right? This is something like a different approach, a preventive approach. And that's what I'm really proud of. When we came together at Johns Hopkins now 13 years ago, 14 years ago, we really wanted something different. We knew at the time that the right types of prohibitions didn't exist. And we could have just said, well, let's add more prohibitions. Let's stop people originally. But this is something different. We thought, I think ultimately we understand that firearms ownership is widespread in the United States. It's just that there are times and circumstances that there are some people who are not appropriate to have guns in their possession. This gives us that tool without criminalizing them. And so I don't know that we realized the magnitude of what we were doing at the time. I don't think I did. I knew it was an important meeting. But the recommendation that we came up with was incredibly important. And if you'll indulge me to go through just a couple of pieces that I think, more than a couple actually, but pieces that I think are important. I'll just quickly go through that list and then we can ask me questions after the other panelists get to jump in. Number one is this is a big public health success. It's, I think, probably the gun violence prevention law that's one of the widest dispersed. In other words, it's gone across many states, and even the federal government has come in and helped fund these issues, the implementation of these issues of this order. And I think Lisa probably has the exact number, but we're talking more than 80,000 ERPO petitions right now. This is not a small public health intervention. It's actually a pretty large and targeted intervention. And Jeff, if we go back to your research and think about the number needed to treat somewhere between, say, 13 to 18 ERPOs to prevent a suicide, you're talking at 80,000 ERPOs, you're talking at public health success. right?
Mhm.
And I
Yeah.
think that's something that we really need to focus on. The research is still coming in. We're still trying to figure the evaluation part of this, but the arrows are pointing in the right direction. That this idea that we developed is really making a difference. And you should be very proud of that, not only for being there at the beginning, but helping to quantify what's going on out there. But I am. I know I am. And I know I'm sure the rest of the panelists are really proud of what we've been able to do here in terms of saving lives. A couple other things. So when I say dispersed, I mean 22 states now have an extremist protection order law. DC and the Virgin Islands, the U.S. Virgin Islands as well. So this is more than half the United States population, right? So it's affecting a lot of people, and I think it's been helpful in that way. And here's I think the piece that why the dispersion is interesting and matters. In the states that we've been able to do this, and you can talk about, we started this in California, then we had Washington, then Oregon, then it spread to a bunch of different states. But when you think about personal experiences I've had, at least I hope you and can jump in here and Kim as well. But there's so many people who are like on the ground saying, "Oh, we'll never do this. This is a violation of the Second Amendment. It's a violation of this. But I can't think about why we'd want to use this." But when you have that situation and you need to use it, you are so glad that it's out there. So we've talked to countless people, especially in the law enforcement community, who said, "Oh, I'll never use this. I'm suspect of this." And all of a sudden, they become the biggest champions. And that's where I figure that I think we've done a really great job. When they get on the ground, when a state, for instance, Michigan passes a law, and then you're out in rural Michigan talking to law enforcement, and they're enthusiastic about this. It fits a need that they haven't been able to reach before. And so that's something that's important. So let me just take a time check because I have a couple more things to add, but would you rather get me to get them in future questions or should I keep going, Jeff?
Just keep going,
All
Josh.
right, great. So, and I think one of the reasons that law enforcement like this is because typically, they're there after something bad happens and they get frustrated, just like all of us watching a train wreck and not being able to do anything. Law enforcement knows, when things are going bad, but they need a certain criteria for a criminal charge. This gets them in the opportunity to be proactive. And, when we work with law enforcement, that's the thing. It's a different type of policing. It gives them an opportunity to get involved before harm occurs. And that's something I think that really enhances their approach to the job and gives them a tool that they just never had before. It's almost like a new kind of policing on this. And Kim, I'd love as a prosecutor for you to jump in on this at some point, but it gives them a whole new approach to this. And we're seeing that I think it helps them think a little more holistically about what's in front of them, what are we seeing, and do we have to wait for something terrible to happen before we intervene? So I think that's something that's really important. Now, when we started this, I had a big fear myself. When you brought up equity at the beginning of this, and one of the fears I had was that there would be an inequitable use of ERPO. In other words, that the communities of color would be affected by this, and that they would be disproportionately impacted, and other types of harms that we've seen across the country traditionally. That's not what's happening here with the extremist protection order. We monitor this. There's not an overuse in those communities. In fact, if there's anything, the challenge we have is an underuse, right? We need to get more people comfortable with this on an individual basis. There is interaction with law enforcement. You might be petitioning, but I want the benefits of ERPO to be spread across the country through all communities. And I think that's a place where we have some definitely some work to do. And that's where, there's not an official deflection or diversion element of ERPO, but I do think in practice it works that way. So if you're not interacting proactively, for instance, you might not have that opportunity for a deflection, right, for deflection. So I do think the opposites happen, which is we actually need to do a better and broader job of getting this out in the community, which is not easy. But I think that's the challenge that we see. I thought the challenge would be the other way, which was overuse. The challenge turns out to be in certain communities, I think that could benefit from this is underuse. Okay. So that's something that I think is very important. And then I want to just finish my opening remarks by saying this. In across the country, that we've seen in many places a dramatic drop in homicide. Where we work in Baltimore, we've seen a really historic drop in homicide, and that is amazing news. What we have not seen is a historic drop in suicide. Firearm suicide is basically by rate at an all-time high, and it has been for the last couple of years. And you got to remember, firearm suicide is the leading cause of firearm death. It's about approximately 60-65%, depending where you are, of firearm death. And if we don't have effective tools, we need to address this. We need to focus on the suicide issue. And I think ERPO is an important tool, extreme risk protection orders, an important tool to combat suicide. And we don't know yet, like, have we affected the overall rate? But to the extent that ERPO can be, and I think your research shows this can be an effective tool for suicide prevention, we need to even broaden the implementation of ERPO with a special focus on suicide because that's a very intractable problem right now. And I think as someone who had a dear friend die by a firearm suicide, I know for one that's where I want to make sure that we're doing a good job there, and I think we have some work to do. But those are my sort of beginning my thoughts about this. And I just want people in how good it is, how important it is that we have a reduced homicide level in the United States, which is great. We need now to focus on suicide and make sure that drops as well.
Thank you, Josh. That was a great overview. And I'll just say before I go to Lisa, if we have evidence that ERPOs can prevent suicide, and yet firearm suicide is not going down in the overall rates, that might be an argument that ERPOs really need to be scaled up and need to be implemented. Because we know they can work when we look at their effect in people who actually have been exposed to that benefit. So thanks again. We'll come back to some of that, Josh. Let me turn to Lisa. Um, Lisa, you spent several years now working directly with ERPO implementers across the country, and your implementation science scholarship with Spencer Cottrell gives us kind of a structured way to understand why ERPO practice varies so widely. So drawing on that framework and on what you've seen in the field, how would you describe some of the major patterns in ERPO implementation across jurisdictions? So, for example, where do you see ERPOs functioning primarily as a public health prevention tool focused on early intervention, behavioral health crisis response, and where do you see ERPOs operating with a little more overlap with the criminal legal system? Where do you see ERPOs, with, let's say, whether through law enforcement champions or petitions or concurrent arrests, or the discretionary uses that we see in our research. And what do you think are the most important ingredients for building ERPO systems that are both effective and fair so you maintain fidelity to the original mission, but you can adapt it to local needs and the dramatis personae in local areas?
Yeah, thanks, Jeff, for having us. I want to just answer the last part of your question first because it tacks along with what Josh was saying. In the last several years that I've been going around to nearly all of the states with ERPO laws, what we've found is that you really do need to tailor your implementation to the needs of your community. And what I mean by that is if your community's gun violence problem is primarily firearm suicides, and there are several states that have the vast majority of their gun deaths being suicides. There are a couple places. I live in Washington, D.C., where most of the gun deaths are homicides. If you are not using ERPO in that way, you are likely missing a large part of the population that could benefit from its protections. Like Josh said, we're not seeing these historic decreases in firearm suicide. In fact, we're seeing historic levels, high levels of suicides. And so, particularly on the suicide prevention piece, if we are not using ERPOs in that way. Same with minors. This is one area that I think is newer in the ERPO state, except in Kim's state of Washington, where they were the first to actually write into their legislation that minors can be respondents to extreme risk protection orders. If states don't know that they can or how, then they might be missing a part of the population that could benefit from its protection. So I always like to say that ERPOs are a living document that can and should be adapted and amended as practice changes and as the crisis changes. But I'll start to the first part of your question, which is how I would describe the patterns of implementation across jurisdictions. And what I would say very top level is that we see ERPOs being done quite differently in different parts of the country. So where Kim is, and she'll talk about this, she and her colleague Shaya have really been a model ERPO site for a while. They know exactly how to use it, when to use it, great partners, great leadership priority. Those are some of the things that we need to see consistently across the board. So, for example, if your police chief or your sheriff is not supportive of this, we don't see this working as well in practice because you need that leadership buy-in and you need that champion. But we do see the agency housing ERPO implementation or that champion on the ground looking quite differently. So a lot of states that I've traveled to, the sheriff's office is taking the lead, or maybe it's the police department or the DV unit within the police department. Sometimes it's the AG's office, sometimes it's the prosecutors, and sometimes it's a public health department or a state's attorney or someone else. So I don't think, and we certainly at the National ERPO Resource Center don't prescribe one way to do ERPO, but you need to have some of those same recipes, elements of the recipe in there for it to be successful. So where things are working well and where states are implementing ERPO equitably and efficiently, we see that there's been a deliberate effort to do so. And what Spencer and I wrote in that article that you're referring to and what we've seen is that a lot of these investments have to be made before a law even goes into effect. And so next week, Josh and I will be in Maine. Their law is very new. It just went into effect in February. And before the law went into effect, we were working with partners on the ground to make sure that the court forms were ready. So day one, if someone really needs and wants an ERPO, they need to know how to get that court form. That goes for law enforcement, that goes for civilian petitioners. So you need that infrastructure in place, which certainly can be costly, but it won't work as well if you're trying to scramble and do this after the fact. And lucky for Maine and lucky for the states that will follow, there has been a lot of states to point to now on how to do this well and a roadmap in a sense already set for the states that are set to adopt it. So deliberate effort to do so. Implementation does not happen on its own, so it needs that deliberate effort. It needs that champion. For law enforcement, we work a lot to refine and create standard operating procedures. So you aren't winging it when an ERPO comes across your desk. You have everything written out, you know who to go to, and you know what to do next. So those are some of the elements of the recipe for success. I want to turn, if it's okay, or I can pause for a second to the different frameworks for ERPO in public health or policing.
Yeah, go ahead.
So in public health, I think one thing I've been surprised by and curious for Josh and you, Jeff and Kim, to see is how many judges and law enforcement and prosecutors are actually thinking like public health professionals. They have that mindset of, we say at Hopkins, protecting health, saving lives, millions at a time. While this is certainly an individual a remedy in a sense that you're getting an order on a particular respondent, this has widespread implications, not just for the safety of that respondent. Maybe they're threatening self-harm, but if they're threatening interpersonal violence, think about all, and there's also a connection, I should say, between interpersonal violence and self-harm. Think about the long-lasting impacts you're having. And so when a judge is deciding to grant an order or a law enforcement officer, family, or clinician or other is attempting to file an order, this is pro-action, this is public health. And so I think in the context of suicide prevention, this is where we see, or at least where I see, public health response kicking in at its finest. I think that people in the past didn't have as many tools to address suicide prevention, and this is really putting that time and space between an individual and their firearm. Now, I think where this gets a little trickier and where we see a little bit more law enforcement interaction and maybe the criminal legal system is where there is that overlap between interpersonal violence and extreme risk protection orders, because obviously there are different responses for someone threatening a mass shooting and maybe different steps that you're going to take versus someone whose primary precipitating event is threats of self-harm or this experiencing acute suicidality. So I do, though, think that we are, like Josh said, changing the way that we are policing and that policing is happening in this country, in that we're not just being reactive. That doesn't mean there aren't people that are being concurrently arrested, because we do see that happening. But one thing that's been really positive and hopeful for me is actually a study out of UW, out of University of Washington, led by Dr. Julia Schlemmer, that looked at arrest rates among respondents, and they actually found that their arrest rates for ERPO respondents are lowest after the ERPO was filed. So there is some data coming out there looking at the role of potentially, like you're very interested in, Jeff, deflecting from the criminal system into a civil system. But that can't happen just simply by enacting an ERPO in your state and implementing an ERPO and hoping things go for the best. There really needs to be an investment, taking it seriously, and like Josh said, connecting respondents to resources to make sure they're getting better while the order's in effect.
Great. Thank you so much, Lisa. So let's turn to Kim now, and then we'll have some discussion. So, Kim, you've been a real pioneer in building an ERPO system that operates at that intersection with public safety and the criminal legal system. You and your colleagues in the ERPO trenches, shall we say, wrote an article I read in JAMA Network Open, a commentary that highlights how ERPOs create a brief window of opportunity to intervene in crises, and the Washington statewide data show how often these cases often involve a range of things. It could be suicidal behavior, substance use, domestic violence, prior justice system contact. So, drawing on your experience in King County, um, can you tell us how ERPOs actually function on the ground when law enforcement, prosecutors, and courts are responding to these situations? How do you see ERPOs being used across the different kinds of situations, sometimes maybe as alternatives to arrest or alternatives to prosecution, sometimes as mitigating interventions or concurrent civil tools, and in some cases even complements to robust law, criminal law enforcement, although that might have been not the legislative intent. Maybe that happens sometimes. So from your vantage point, what does it take to ensure that ERPOs are used in ways that are both effective and procedurally fair, especially for people in behavioral health crises who might otherwise be pulled deeper into the criminal legal system?
Well, thank you, Jeff. Thank you for having me, and to the Wilson Center and Johns Hopkins. I'm honored to be here. Just to touch a little bit, and then I'll break down your question as we go through. I would say, to bounce off what Josh and Lisa said, a lot of what I found myself doing in the early years was dispelling myths. Telling law enforcement, because you get these calls and they're like, what is a red flag? What is an ERPO? And as Josh said, and once you have somebody with law enforcement realizing, hey, this is the right set of facts, because in Washington, and just like in the other states, we can move so quickly to have this civil intervention to get that person off the pathway to violence. Then law enforcement is calling us again and saying, hey, remember when, so we get the vast majority of our outreach. Once somebody has done one ERPO, we have them coming back from their department saying, hey, we want to do that again. But I think the greatest success, and I would say, is, my colleague and I, we've been longtime prosecutors. I've been a prosecutor for 25 years, my colleague 30 plus years. We started noticing something very unique happening that we hadn't seen in the prosecution side, right? As prosecutors, our role is to do justice. And even in the ERPO side, it's not to win ERPOs necessarily, right? We don't look at it like that. It is, how are we going to prevent the gun violence with a civil tool? And as you and Josh said, how are we going to get people to get better? So something unique started to happen when in the last couple of years, we saw respondents coming in, often in self-harm cases, but sometimes also in threats of mass violence cases. They would come in and they would thank the crisis response officers from the Seattle Police Department that were intervening. And it was this powerful interaction where they may not even agree with the ERPO at the time, but they understand why the court is doing it. But before the proceeding would end, they would thank, the officer for how they were being treated. We had somebody who said one time, I just want to thank officer, I can't remember which officer it was at the time, because they intervened when basically they saved my life when nobody else was willing to do it, right? So we saw these powerful moments. And for me as a criminal prosecutor, it was a real shift. When I started this work in 2018, I didn't know what I was doing. There was no roadmap really. I started showing up in court. I was a little more adversarial because that was the system I was used to. And I quickly realized this is a different proceeding, right? We don't want to stigmatize people who are at the lowest points in their lives. And so you see that, at least in King County, by and large, you see law enforcement. And even I think the the judicial officers that are reviewing this really trying to take that preventative approach and not be punitive. So I would say I have to frame it that way because I think that's what we're talking about. And in part of that work too is really learning that, okay, you know, an individual, somebody who's threatening self-harm, which we have quite a few of those cases, you know, that may be a little bit of a different hearing than somebody who's on a threats of mass violence, right? Who called a crisis line and saying, just a couple weeks ago, I'm having ideations of wanting to commit a mass shooting in our area, right? That response may be a little bit different. But the goal there is both to intervene and make sure, one, they can't purchase, and make sure that they're going to cooperate with law enforcement to surrender. And then where are we in that system to intervene to get them the help they need? So we see that in with the crisis response folks co-responding with mental health professionals, with the court's ability to order a behavioral health evaluation. And then, of course, we need more funding to be able to get those people the services they need. And just kind of circling back to your question so I don't take up too much time, just to give a real quick framework, in King County in Washington State, my colleague and I function as two prosecutors in our unit, along with our ERPO advocate, who does a great job assisting any families that need help filing for ERPOs. And we want to make sure that families that are in crisis also have somebody in a resource, right? Because my colleague Shai and I serve as that resource for law enforcement, but we want to make sure that there's also resources for families in need. And we function and assist law enforcement in every aspect of that process. So we're on call 24/7. So often they will call or sometimes we're outreaching, right? If we get an incident report and maybe that criminal case is not going to be filed, as Jeff said, where do we intersect in the system? Maybe the family members or the victims or witnesses don't want to participate in the criminal process, but they really want their loved one to get substance abuse treatment and not have a firearm. And there's concerns there. So we're sometimes getting those from incident reports that come into the system where we have concerns about someone's possession and access to firearms, and a civil ERPO could be used as a gap filler there. But to go back a little bit, so Shai and I are assisting law enforcement 24/7. We assist with the on-call part. So we're screening ERPOs with law enforcement, assisting with the filing, make sure we're getting those to the judge for the judicial officer to review that filing. And then we're appearing in court as well. And I think an important part of our role too is what happens between the service of that ERPO. Are we getting all the firearms at the scene? And then the compliance part after an extremist protection order is also issued by the court. And then finally renewal, because the ERPOs are designed to be temporary, right? So we know they're going to expire pretty quickly, or not quickly, but that year is going to go by. And somebody needs to be reminding law enforcement or those family members, hey, it's about 9 months before expiration. Do you still have concerns? So our unit is doing all those steps throughout the process. And just to very briefly turn to some of your other questions, you talked about how to ERPO's use across different roles. And I would say they're definitely an alternative to arrest at times. So we have a lot of crisis incidents where folks are being maybe detained on a civil involuntary treatment act, ITA in our state, that's what it's called, process. And it could be a crisis situation. It could be self-harm. It could be even threats of mass violence occurring. And we're seeing ERPOs fill that gap because maybe they're having that civil commitment process, which we may not even know about because of HIPAA and other things, right? And law enforcement's sometimes involved in that, but we want to be able to move really quickly to make sure that we're mitigating that risk. And I think what's really helpful too is trying to build relationships with social workers up at maybe the hospital that are detaining people on ITAs, right? To make sure, okay, before this individual gets released, if it's self-harm or threats to others, has law enforcement or we've been able to make sure that there's no firearms remaining in that home. So I would say that's an important intersection with behavioral health crisis cases. And then I would also say, as I said, there's times where we're going to use a civil ERPO if we're not going to be able to file criminal charges, but we have concerns about access to firearms. And also there are, a handful of times where we've had very significant criminal investigations going on. I'd say that's pretty rare, but we've had situations where maybe that ERPO is that first step to disrupt, de-escalate, and intervene while that criminal investigation is going on. We've had that occur, maybe we're working on civil search or criminal search warrants, into an investigation concerned somebody may have a manifesto or threats of mass violence plan, and sometimes even with partnerships with our federal partners, and they're picking up part of that. That's pretty rare. I mean, most of the ERPOs are not involved in that way, but it's been very effective, I think, to intervene from law enforcement perspective because we can move so quickly and effectively. And finally, I know I am over my time here, so I'll wrap it. But I would say one of the things that I think is so that's been a significant change, and I think for folks that are with self-harm cases, is the ability for those individuals to seal their petitions. And I think that should be something that should be spreading. I don't know what it's like in other states. I haven't actually studied that, but I wasn't sure how I felt about it in the beginning because it's the only civil protection order in our state that can be sealed for self-harm, and all juvenile cases can be sealed too. But I really think that's very important because it gives people at this very delicate and probably the lowest points of their lives some dignity back, right? Because they're coming to court. We're really trying to say we're intervening to be preventative. And I think that's something I would say is a big advancement that we've done legislatively in the last couple of years that's been really effective.
Great. Well, thank all of you. So let's just back up for a second and let me just say something about the problem in the policy landscape and then focus here on a couple of questions. So what we're learning here, we have from a kind of public health point of view, this problem of firearm-related injury and mortality. We live in a country where private ownership of firearms is very prevalent, and it's not going away. It's protected by the Constitution, according to how the Supreme Court has interpreted the Second Amendment. And neither is injurious behavior going to go away. I mean, we're not going to live in a world where we don't have people, for a whole variety of reasons, inclined to harm other people or themselves. And so and the challenge is that we can't just, broadly limit the people's access to firearms. The tools we have at the point of sale to keep guns out of the hands of dangerous people are kind of blunt. They are a little bit overbroad and narrow at the same time. So, given that kind of puzzle, what we have is a versatile legal tool that can be used to separate a firearm from that person who might be in a crisis where they're going to injure somebody temporarily in a way that's not criminalizing. And we have some evidence that this works. The problem is it works in half the states that have the law, but the other states don't have the law. And then we have although we had what seemed like a kind of golden moment of consensus where people across the political spectrum and people who are gun owners and non-gunners agree this is a good idea because it's a tool that can work and it's not gun control. It doesn't affect the rights of, people who aren't dangerous and legally own firearms. But the problem I want to focus on here is, we all kind of agree with each other. This can be a good tool. We need to learn more about how to, use it in a way that's going to meet the needs of the community. But there is resistance too, and that I think comes from a lot of misinformation about ERPOs, and we hear people who think there's a big problem with due process, or there could be unintended adverse consequences from ERPOs. So I wanted to ask the question about public trust. I think ERPOs to work well depend on the trust of the actors, but also the public. So what kind of strategies do we have that are effective in building the legitimacy of this tool so that we can overcome resistance to it? And I don't mean this to be a political question, but in communities that might be skeptical of law enforcement, maybe skeptical of government intervention, how do we think about moving from what is a modest success now to the potential if ERPOs could be scaled up? And maybe that comes down in part to training. I mean, Lisa, maybe you could say something about that. Like you're going to Maine. Well, the new law is replacing an old one that people had some problems with, and you had perceptions that it didn't work very well because of how the law was written. How do you go there and you get people to know this exists, but also to be able to see the potential in it and not be resistant? Anybody can answer that, but I think that's a question I have in my mind. Josh, I think you're muted,
I'll
Josh.
start because I was
Yeah.
about to say I'm off mute. So there's lots of things to build trust, but a couple of things I want to make the point. First of all, the public is very supportive of this, and the polling that we do across the country, we see a lot of support. What I think where people lose support for laws is when they don't work or they don't actually, where the mechanism isn't enforced. One of the nice things about extremist protection orders is that a lot of them are followed by law enforcement, and and almost always a firearm is removed or they're prevented from buying a firearm. So it's the respondent. So these laws are actually being executed, which I think is a really big part of trust. Because oftentimes people say, well, we supported this law and no one's enforcing it, or it's not necessarily working, or we're not seeing results. What I like about ERPO is that public will trust things that are actually getting done rather than just people mouthing off about something, right? Here in this sphere with this law, there is a result. Firearms get removed from people who are at risk. That actually happens. It's not a piece of paper that gets filed and maybe gets served and maybe it doesn't get served. These things you see a high degree of consistency across the country actually get accomplished. And I think the third piece of this is that when you look at places that are high use jurisdictions, for instance, one of the places, and I think about Florida a lot, you have sheriffs across Florida using this law in a very, very pro-gun state. These sheriffs are often very pro-gun themselves, and they see this as a way to be proactive. And I think nothing sort of builds the trust of someone who's saying, look, I have firearms. I own firearms. I'm a pro Second Amendment guy, but in this circumstances, we need to remove firearms. And we're seeing that around the country. That people who this isn't about being pro or whatever, anti whatever. This is about results. And when you need this order, it actually works. And law enforcement in the states that we have it are using it successfully. And I think that's what builds your trust. So in Florida, which is, yeah, I think maybe outside of New York, I'm not quite sure the latest numbers, but it's the highest use state in the country. And you're seeing just this wide dispersion of use in Florida. So again, it works. I think there are people who are sort of non-traditional actors in this field using it. And I think the public supports these. So I think we need to know more about it, right? I mean, people need to have a higher degree of sort of knowledge about ERPO. But I really think we're building the right way. And as I said before, my biggest concern is that there are communities who have historically, not trusted law enforcement or been, have bad outcomes with law enforcement, where we need to focus when I say we need to focus the opportunity of ERPO, because I don't want people to lose out when I think it's a powerful tool for violence
Yeah.
prevention across the board.
If I could just add to that, Jeff,
Sure.
I I think Kim started off by saying a lot of her job at the beginning was myth busting, and I do believe that's something that Josh and I do a lot as well, because there are folks who have either never done this or have maybe seldom done an ERPO, and whether we're talking about law enforcement or others that think it's going to be some huge standoff, barricade situation, which I'm not saying never happens, but I will say it very rarely happens. And so I think that the way to build trust is, like Josh said, to show that it works, but also do it in a human-centered way. And I don't think that there's a place doing a better job at that than King County, than Kim and her colleagues, because they recognize that at the root of the ERPO is someone in crisis, someone who's having hopefully the worst time of their life, and what they need is to be talked to like a human and with dignity and respect, and recognize what an ERPO is, which is temporary limit on their access to firearms, and what it isn't, which for some people won't involve involuntary commitment, for some people won't involve criminal charges, for some people, it's not, doesn't have the protections of a domestic violence protection order if you're looking for no contact or stay away. And so recognizing what it is, what it isn't, and realizing that around the country, with very few exceptions, this isn't SWAT going to your house and knocking down your door and serving you an order and having a hostile situation. I would say 99 times out of 100, we hear that service goes well, that there's respect on both ends, that people consent to orders quite frequently, and that this can be done in a very calm, civilized way and happens that way quite often.
Yeah. Thank you. So, from the point of view of the research evidence and thinking about what counts as success, like what can we measure where we say that really indicates that these are working. One of the areas that's been challenging is to actually get information from people who have been respondents themselves to ERPOs and have had the experience. Um, and then, maybe after the fact would have an opinion about whether it was a good thing or not. And so I'm wondering, maybe, Kim, you have some experience, anecdotal or otherwise, about people themselves who've been respondents to ERPOs and look back on it and see this not as something punitive, but maybe something that was helpful, or maybe helped them because it was a portal into getting some kind of help or benefit, or maybe not going to jail or something like that. We're trying to build some evidence in the research about this, but it's a challenge to do that, particularly to get representative information from folks. Do you have any information on that?
I just have a couple stories that
Sure.
I know of, and going back to some of our great law enforcement partners that have more specialized training in crisis related incidents.
Yeah.
For example, there's one officer in Seattle Police Department that I've heard that still goes out to lunch once a year or so with the ERPO respondent from many years ago, or they still are
Mm.
connected because
Yeah.
that individual was really appreciative of the intervention. Now, I don't know if they were appreciative of it at the time, or if that
Yeah.
after the fact and after some therapy and some other stabilizing factors, that individual obviously is still reaching back out to that officer, which is a pretty unique situation. So I definitely have heard of that occurring. And I also think, I think it's hard to measure, right? What you're saying.
Sure.
What I am sort of interested in looking at some of these cases is more kind of in threat assessment terms. Maybe that's not exactly what you're saying for research, but where are these individuals, our ERPO respondents, on the pathway to violence, right? Because we know that a pathway to violence, which is, a threat assessment term, the Secret Service does that, all different types of studies on individuals after mass shootings and stuff. If we analyze some of those factors and we look at some of our ERPOs that are coming in and our ERPO petitions, and maybe a year or two later, where were some of these individuals from a threat assessment perspective on the pathway to violence, and have they stabilized? And I can tell you, I also think having folks being subject to a behavioral health evaluation and getting funds to be able to pay for it would probably get more folks able to respond, right? Because
Yeah.
courts ordering behavioral health evaluations, at least in our state, we're not able to fund those from a state perspective. And I think if you get people earlier intervention, so we're not waiting until the very end of treatment where we're asking them, have you done your behavioral health evaluation that was due 60 days ago, right? So if we can get more upstream and upfront with that, I think we'll see perhaps more ERPO respondents that are willing to engage in that type of research. I don't know, Lisa, I know you did a study with respondents, so she might have some greater insights than I do.
Well, I'm sure you have spent more time with respondents than I have, but yes, I have a paper under review, so a couple papers under review. So I won't say too much about it, Jeff, in case you're one of our reviewers, but we did, the team at UC Davis and a couple of my colleagues at Hopkins were able to interview respondents in California. And so we interviewed 24 respondents who, including minors, and I led a paper looking at minor respondents that's also under review. They were not minors at the time of the interview, but I think there were some real challenges that came from the ERPO experience and potentially some complications for some folks in terms of the ability to keep a job or get a job, depending on who's running a background check and where it might show up. But by and large, we were we were happy to see that the consequences weren't so severe that this whole system needs to be completely uprooted and started from scratch. And in fact, a number of respondents, both minors and adults, used the ERPO as an opportunity to reflect on what had been going wrong at the time, and some of the same sentiments that Kim was saying from respondents in Washington, that they were actually appreciative that someone got this, that it didn't have huge negative consequences on their life, and that actually not having access to a gun was a good thing for their safety and others' safety. So more to come on that. We have several papers that should be out this year.
Thank you. So I have one other question, and then I'd like to see if we have any questions from the audience. So this is about, unintended adverse consequences. What do we know about ways in which maybe ERPOs might have been used inappropriately, or, things that would give the critics of ERPOs some ammunition, so to say, look at this. This is something that does not respect people's rights or whatever. I mean, we know people certainly say this, but and we've tried to learn as much as we can about this. But do we have something to say about that? And what the implications of that might be?
Well, I think just real quickly, just to protect, I think, the integrity of the ERPO statute,
Yeah.
right? We're very intentional about not doubling up. I know different jurisdictions and states have different policies and different views on that. But if somebody's already a felon and
Yeah.
they're prohibited from possessing a firearm, our civil ERPO is not going to add much of anything, right? So we are very
Yeah.
intentional in our practice in saying that's not the best use of the tool, both for law enforcement, because law enforcement resources are thin, and second, if we need to enforce something because somebody's a felon and we think they're in possession of a gun, that is a criminal intervention, right? Not likely to be civil. So we are intentional in that way, and we've been that way from the very beginning, and still are by and large. So we don't typically double up on orders. We try to enforce the one that if there's a civil order, if it's domestic violence, then we're going to try to enforce that civil domestic violence protection order with that order to surrender weapons. And, so that's one policy decision that we have made. And I'm not sure if Josh or Lisa have anything else on that.
Well, Lisa, I think you probably talk to more implementers than anybody around the country, but obviously I do as well. And the sort of bad outcomes are far and few between. And we don't see a lot of abuse of the system, and I think that's for two particular reasons. One is, well, maybe a couple more, but I think the statute itself requires judicial intervention. This isn't just, oh, let's go take someone's firearm away. A judge has to approve even the temporary order. So that's number one. The penalties for lying on these. So, and judges are pretty good at figuring out, I think, who's sort of making stuff up, who's telling the truth, who's using this. We heard, oh, will this be used vindictively? We're not seeing that at all. And if it is the case, I think judges are really good at weeding that out. Um, I think the other thing is that there's a severe penalty if you lie on these forms. It's perjury. It's a
Yeah.
felony for most states if you lie on these forms. The third thing is most ERPOs are brought by law enforcement. Like even in states that family can do it, most of them are brought by law enforcement. And our experience is that it's been done in a very thoughtful approach where they're really not only trying to protect the public or the individual being harmed, but trying to take an opportunity to intervene so that, as Lisa said, on the person's worst day of their lives, things don't get compounded, right?
Yeah.
So we're just not seeing that, oh, this is going to be used as a vindictive tool. This is, there's multiple layers there that are preventing that. And it's certainly not in any widespread effect that we're seeing. Lisa, maybe you want to add on that.
I agree. I think there's very little evidence of misuse, and I think there's always room for improvement. I think a big gap could be connection to services. It's by far the most common question I get asked when I'm training in the field is, okay, so you took their firearms, now what? So I do think that there is an opportunity to make sure that the person is getting better for whatever that precipitating event was, and that still remains, I think, a big gap in a lot of the a lot of the states. But again, that's not necessarily the fault of the ERPO. That's not how it's written. So I don't want to blame the ERPO for that, but I do think there's an opportunity potentially to amend it and focus more on services for respondents.
Okay, so we have just a few minutes left. Jennifer, can you give us a question or two from the chat if we have any?
Sure. The first question is generally, what are the consequences for respondents to civil ERPOs? Diversion from criminal proceedings seems to be a benefit of ERPOs. However, what is the role of criminal penalties? Are violation of ERPOs generally subject to criminal penalties that someone would otherwise not be liable for?
Well, if I'm understanding the question, if it's okay,
Sure,
Jeff,
please,
if I jump
please,
in. Okay.
yeah.
You know, so it is a civil court order, but there are consequences. For example, if somebody did not surrender all their firearms and is found with a firearm, like in our state, it would be a gross misdemeanor. I will say that that is very rare. If somebody in the situation, like law enforcement goes to serve somebody and they're like, nope, go get a warrant. I'm refuse, right? That has happened like twice that I can think of since 2018, right? And so very, very rare situation. But if somebody is found with a firearm later and they're subject to an ERPO, and at least in our state, the first offense is a gross misdemeanor. We do sometimes see folks who have significant behavioral health concerns. Maybe they're subject to an ERPO and then they're going out and trying to purchase a firearm, right? So that they're going to get a denied firearms transaction. So we have seen several of those before, which potentially could be a criminal charge too. But I'd say it's pretty rare, honestly. Very, very rare for us to intervene criminally on an ERPO with a search warrant. I would say a couple times a year we're having those discussions with law enforcement, but it's very, very rare. I'm not sure if that answers the question.
Yeah, thank you. Other questions, Jennifer?
How do you see the practice of issuing an ERPO even if somebody does not have access to a firearm?
I'm happy to start with this. I think this is a great question. I'm glad that this was asked because you can use an ERPO in all the states when someone doesn't currently have a firearm but could otherwise access firearms. So again, it prevents the purchase as well as possession. And where I like to hammer this home is when we're talking about ERPOs in the context of minors. And one example that I point to, and I've written on this with Josh in Health Affairs, is that the Uvalde shooter purchased his firearms 23 minutes after he turned 18. Now, of course, Texas doesn't have an ERPO, but if a state had an ERPO against a minor, let's say in Washington State, or even in a state like California and Delaware where you can get an ERPO for 5 years, you could have prevented a purchase potentially in a situation like that, even when they weren't legally able to purchase it, if they were to reach the age of majority while the ERPO was in effect. So we certainly in our trainings like to emphasize that this can be used when someone doesn't have access to firearms or doesn't own a firearm, but would be otherwise able to purchase one.
And we've had situations where a loved one has reached out and said, I'm concerned my loved one is threatening suicide, and they've said that they've purchased a firearm and it's in the background check process. And so we have used ERPO, or law enforcement has used ERPO and families to intercept that pending sale. And that has happened. That happens at least probably a couple times a year, I would say. There is that intervention. So it doesn't mean they may not have it yet, to your point, right? But there's knowledge or there's an expressed intent to purchase. And so we want to make sure we're preventing that actual firearm being delivered, if that makes sense.
So let's take one more question and then we'll need to wrap up. Is there another one?
There's one more. There are worries that ERPOs could be used by people perpetrating violence or abuse with the goal of disarming the person they are abusing. Is there any way to measure to what extent this is happening, if at all?
Yeah, I'm happy to jump in there. I don't think that's ever happened. I think it's pretty clear that's just that's the kind of thing people make up some kind of fear with. We're just not seeing that around the country. And again, the vast majority of these are done by law enforcement. So it's just not, I mean, there are people who do families, and it's important for family members to be able to do that. But the vindictive ERPO vignette is just not something we ever see.
So I guess we should wrap up. We're at the end of the hour. I'd like to thank everyone for tuning in to us here, and to thank our panelists. This has been, I think, very informative, and I've learned some things. I think, we just to think about it, firearm injury and mortality, gun violence is a very significant public health problem. If it's not a public health problem, as Dr. Satcher said, why are so many people dying from it? And so I think this is something that it's not a panacea. It's not the be all and end all to solving gun violence, but it's a really important legal tool and policy tool that is promising, but it has a long way to go to achieve the potential that it has in concert with other kinds of approaches in our country. But I'd like to thank all of the panelists here, Kim and Josh and Lisa, for what you guys are doing with this to help it achieve its potential and to overcome some of the barriers. So I'll end with one word: onward. So thanks very
Thanks, Jeff.
much.
Thanks for having us. Thanks to everybody who put this
Thank
together.
you. Thank you
Thanks
very
for
much.
having us.
Well,